Okay. The United States Court of Appeals for the Ninth Circuit is now in session.
Good morning. I'm Judge Bennett, and with my colleagues, Judge Miller and Judge Sung, welcome to the Ninth Circuit. We have one case on the argument calendar today, Governor Gavin Newsom et al. Versus President Donald J. Trump et al.
Unfortunately, local authorities are either unable or unwilling to protect federal personnel and property from the mob violence ongoing in Los Angeles today. Under these conditions, the president acted well within his discretion in calling up the Guard, based on his determination that the violent riots in Los Angeles constitute a rebellion against the authority of the United States that rendered him unable to execute federal laws. Yet the district court improperly second-guessed the president's judgment about the need to call up the Guard in order to protect federal property and personnel from mob violence in Los Angeles.
Is it the United States' position that the court has no role at all in reviewing what the president has done in calling forth the militia under subsection 3? Or is it the United States' view that the court has a limited role and needs to afford the president very substantial deference? Or is it something else in deciding whether the requirements of subsection 3, inability with the regular forces to execute the laws, is met?
Thank you, Your Honor. Our view is that this statute commits the decision whether to call up the forces to the president's unreviewable discretion. So no, there's no role for the court to play in reviewing that decision.
A stay pending appeal would profoundly injure the state of California and our nation more generally. It would allow defendants to continue diverting thousands of guardsmen away from critical work at the state level, including wildfire prevention and drug interdiction. It would allow defendants to further escalate tensions and the risk of violence in the city of Los Angeles. And it would defy our constitutional traditions of preserving state sovereignty, of providing judicial review for the legality of executive action, of safeguarding our cherished rights to political protest, and of keeping the military.
I'm happy to talk further about the conditions, but I'd also like to talk about the second issue that the district court focused on, which was whether the Secretary of Defense committed a technical violation of the statute by not issuing the orders through the California governor. As you know, the district court found that the Secretary of Defense committed a procedural footfall by not issuing the orders through the California governor. But under the statute, the governor is merely a conduit, not a roadblock or a co-executive when the president decides that it's necessary to call up the Guard.
All right, we thank all counsel for their helpful arguments, especially on an expedited basis. We thank counsel for appearing remotely. I would also simply note that the panel is cognizant of the fact that you have another hearing set on Friday before Judge Breyer. And again, thank you. And with that, the court is adjourned.
This court for this session stands adjourned.